Hello, everyone. In this lecture, we are going to continue our study of comparative law. Today, we will examine the principal schools of comparative law methodology. You may remember last time we said that to compare can mean different things. It could mean the fact of comparing, which we all do, but it can also mean a specific field. Comparative law, especially after the 1900s, came to mean a certain specific autonomous field of studies. And therefore, if we want to pursue studies in comparative law, we must know the major methodological approaches or schools of the field. But before we begin, it is better to think about certain epistemological questions. First of all, is methodology and methods necessary for comparative law? Of course, the broad answer is yes. Method and methodology are methodology as a science of studying methods is of course necessary for every kind of scientific endeavor. But today, before the comparatists rarely studied their methods. Today, there's a lot of studies about methods at the point that sometimes comparative law may be confounded with the study of the methods of comparative law. Another question we can think about is comparative law just a method or is it an autonomous discipline? I think we already discussed this last time. So if we consider it to be an autonomous discipline, there are certain schools or approaches that we ought to know, and these will be the object of the first part of this unit, schools of comparative law. In another lecture, another video, we will talk about the process of comparison. So today our discussion will be about the schools of comparative law or approaches. Perhaps it is a better word, approach rather than school. So the four approaches we are presenting are not the only ones that exist. We are going to focus on three mainly. The functional approach, اللي يقول functionalist أو الapproach functionalist, الوظيفية المقاربة الوظيفية. Then we have the structuralist school, approach structural, المقاربة البنيوية. And then we have the cultural approach. And we will mention quickly two more other approaches. So let us start with the most influential approach, functionalism or the functional approach. So for much of the 20th century, functionalism was considered the dominant methodology in comparative law. And even today, most studies are functional. We may have spoken a bit about this approach last Thursday. Now we will go deeper into it. So first we are going to present what is the functional approach, and then we are going to mention the criticism that were addressed to this approach. So functionalism begins with a simple idea, simple premise. All humans face the same legal problems. A human is a human wherever he is, and therefore a human is going to face the same problems and therefore the same legal problems. However, solutions are not the same. So the first premise is that humans face the same problems everywhere. The second assumption is that every system must have a legal answer to every problem, but these legal answers are not the same. So the object of the study of the comparative researcher is to find out why there is different solutions. So first he's going to identify the problem, then he's going to identify the applicable rules, and then he's going to think about the difference and about these, why these rules are different. Why is there a difference between these rules? The typical research question that a functional comparatist will ask will look like this. Which institution in system B performs an equivalent function to the one under survey in system A? Or how does the legal system of countries X and Y achieve function Z? We can give an example. French law, when it comes to pre-contractual negotiation, and I think you are certainly familiar with this notion. So when people are negotiating before contract, they must act in good faith. And if some of them is not loyal, in French law, especially after 2016, we have now rules, written rules in the code, in the French Civil Code, that tells us what should be done in case if one negotiator was not loyal. With English law, where usually good faith is suspicious when they ignore the concept of good faith in classical contract law, if such a question arises, how or what would be the answer? Then the comparatist will have to look inside the English legal system, find out how such a problem, will find a solution. So the functional approach would start by focusing on facts as a starting point in the problem posed in system A. From these facts, we're going to see which are the rules in the home system that give an answer or solution to these facts. And then we can see what is the function of these rules in the home system. And then we go to the other country, to the system, to the other element of comparison. How is this function fulfilled in the foreign system? We will identify the rules in the foreign system, and then we will end up with a comparative conclusion. The scheme you see in front of you is taken from a book by Geoffrey Samuel about the methodology of comparative law. So researchers will have to identify the applicable rules in the other system. And this is not an easy task. This is not an easy task. When the answer is in a code, in a written code, such as the French Civil Code or the Italian Civil Code or the Lebanese Code of Obligations and Contracts, yes, it might be easy. But usually the solution is not just contained in the codes. They have to, a comparatist will then have to research precedents, case law, what in French we call jurisprudence, يعني الاجتهاد, or doctrinal reviews, الآراء الفقهية, in order to find that applicable rule. But sometimes these rules are informal. They might be customs, araf. They might be informal, meaning they're stemming from the society, but they are not written or found in any one of the sources we know. In our system, perhaps you remember when you first entered law school, you were told that law has 4 sources: legislative written laws, and legislative acts and legislative acts, case law, jurisprudence. Here, just you have to pay attention that the word jurisprudence in French means ijtihad, while jurisprudence in English means doctrine. So the 4 main sources are written laws, jurisprudence, customs, and doctrine. Sometimes we cannot find the applicable rule within these sources, so we have to see, we have to analyze their society, the society of the other country. Sometimes the law, or the applicable solution will stem out of an extra-legal phenomenon, and this makes the comparison more difficult, but also more interesting. It makes it more interesting. One of the reasons why finding the applicable legal rule in the other system is not always easy is because of a law we call the law of substitution, principe de substitution fonctionnelle. So if a certain legal institution no longer serves its purpose because of social changes, and it was not modified, people will need a solution. So the existing law is no longer fulfilling the function, but the problem still exists, and therefore the people, from a bottom-up kind of way, will find other solutions, sometimes by subverting other legal rules. I will give you a quick example: the irrevocable mandate in Lebanon, الوكيل غير القابل للعزل. It is used nowadays in certain usages for which it was not made meant to be. So the population's legal population practice in general is using the irrevocable mandate in ways to substitute for other functions, especially because those and other functions are not working correctly in the context of the Lebanese economical situation. Uh, what were the major criticisms against the functional approach? The first criticism is that it focuses excessively on technical solutions. Uh, so, adversaries or opponents to the functional approach have said that functionalists focus too much on the technical comparison that they end up by ignoring the bigger picture, the deeper reasons for difference, the overall structure of the system. And it fails to indicate how a legal system is put together in terms of structure and classification. Now, this criticism can be, uh, we can reply, we can answer to this criticism by saying that a functional research will end up at a certain point in dealing with the structure of other legal systems. The second criticism is that functionalism may lead to bias. For instance, I just mentioned earlier that if I want to find the rule, the applicable rule in the foreign system, I'm going to search for it in the four sources of law, which I already know. But not all systems rely on these four sources of law or gives them the same importance. In our systems, the legislative texts are the most important source of law. In other systems, it might be customs. In other systems, they might not know legal text. They might rely only on customs. So here I'm extrapolating what I know about my own system on the other system. This is not a very sound methodological approach because I ought to understand the other system as it is and not project my own vision of my own system to the other system. And if, for instance, if I'm comparing between Lebanese law and, say, the laws of an Amazonian tribe, a tribe living in the Amazon, I should not expect to find any written laws there, or even perhaps any written jurisprudence. I will try to know what their sources of law are. Perhaps customs, perhaps some divine text, perhaps some hazard, things coming from hazard. No one knows. So there's danger in functionalism in projecting our own legal culture to the culture of the society we're comparing with. Some people call that legal imperialism. It might also lead researchers to express judgment of values. Like this system is better than the other. The solution provided by the system is better than the other. So about the first criticism, as I said, a functionalist approach will inevitably lead to discussing the structure of legal systems. So we're not avoiding a research on the system itself. We're not avoiding the bigger picture. However, it remains that the first aim of a functional comparatist is functions, not the whole system. He would study the whole system, but to serve his essential research, which is research about functions, comparing functions of between different systems. I hope you have understood this idea. It means that this criticism is not fully justifiable. Yes, a comparatist, a functional comparatist, is not seeking as a first aim to compare systems as a whole. However, by comparing functions between systems, he will inevitably have to address the problem of the bigger picture. So it leads to a bottom-up approach to comparative law. We start with the case in country A, how it would be solved in country B, but by discussing the differences in solution, we will have to discuss the differences in structure that lead to these different solutions. About the second criticism. Now, it is true that when we do a functional comparison, we may find, after all, that the solution in country B is better than the solution in country A. It was more efficient. Now, based on such conclusions, the World Bank issues a report called Doing Business Report, in which the World Bank compares between the economical and financial efficiency of different legal systems, and they will rank them. Like, this system is better to do business in than this other system, and usually it is the common law systems that are up in the list. This, in fact, may lead to a judgment of values and to a classification of systems based on their economical efficiency without a thorough understanding of their internal dynamics. Maybe there are other ways to do business there. So we must be just comparing based on certain criteria set by the World Bank, criteria that might be natural in common law countries but not totally adaptable to other countries. We're doing a comparative research based on that, and we are getting to the result that these countries are better than others in terms of economical efficiency. So some people are criticizing this. Some scholars do criticize this approach, meaning that no, the object or the mission of a legal comparatist is not to do a classification or ranking of countries. It is to understand these other different legal systems. So I leave it to you if you feel that functionalism would be your favorite approach or not. The second most important approach to comparative law is a structural approach or structuralism. If functionalism focuses on legal solutions, structuralism focuses on legal architecture, in how the system and all is designed. So the central concern here is not what the law does, but how the system is organized. Again, we'll present the main ideas of the structural approach, then the criticism addressed against this approach. So functionalism may seem as a micro approach because we're starting from a certain case to highlight a certain function, whereas structuralism is a macro approach, meaning we are looking at the systems as a whole. So the structural approach focuses on the structure of the legal system. It examines the relationships between legal concepts, notions, institutions, and categories, as well as the relationship between these elements. For instance, we can compare legal structures such as the major conceptual divisions. Perhaps you remember that the first week you entered law school, you were told we have something called private law and something called public law. A legal thinker in France or Lebanon or in the Romano-Germanic system will think of law through this paradigm, that every branch, every legal rule would be either private or public. This is not the way a common law lawyer would think. A UK legal thinker or a USA legal thinker will not think of law based on this division. So this would be a comparison, comparing the summa divisio, in the big divisions, those big categories between two legal systems or traditions. Again, another example would be the distinction between things and persons. بين الأشخاص والأشياء. Les choses et les personnes. This is a very important and structuring division or classification in our legal system. Distinguishing between personal rights and real rights, حقوق العينية والحقوق الشخصية. So here we are not studying a function or a case in general. We are studying how law itself is organized, how the elements of a legal system are organized. Or we can compare also the structure of norms, especially their sources, for example. We follow the hierarchy of norms according to Kelsen, but do we follow it in the same way as Germany, for instance, or Italy does it? In other systems, do they even have a hierarchy of norms? So here we are comparing the hierarchy of norms, not starting by a single case or a function. We are seeing how the system itself is hierarchized, is organized. So structuralists can be seen as a scheme of intelligibility, une grille de lecture, allowing us to find a narrative to make sense of the different elements of a system. And it gives coherence to the legal order. It helps us to make sense, to give a certain coherence to a legal order. And it explains how systems end up creating new elements. And for instance, if before the main distinction between patrimonial rights فرق بين الحقوق المالية كان بين الحقوق الشخصية والعينية personal and real rights, then later on with the emergence of IP laws, we got a new category called the حقوق الملكية الفكرية, intellectual property rights, that were added to these two main categories. Here's an example. Classification. Taxonomy is the science of classification. When we speak about taxonomy, it is how we are classifying things. So in private law, the main division, the summa division, is the division between persons and things. When we speak about a summa division, it means that it is a division at the very top, that any elements would be either this or that, no alternatives. In our legal system, anything could be either a person or a thing, and there's no in between. Persons, we can distinguish between physical persons, الشخص الطبيعي, and legal entities, الشخص المعنوي. Here, please avoid at all costs translating from French a moral entity or a moral person. It will have a totally different meaning. The French expression personne morale, الشخص معنوي in Arabic, means the legal entity. But when you speak in English about a moral entity, it gives it a whole other sense. Morality in the sense of akhlaq, of virtues, of ethics, not that it is a legal entity. So the correct translation is legal entities. These legal entities may be private or public. Public such as the state or municipalities, private such as firms or football clubs, etc. On the other hand, things, الأشياء, they could be either corporate or incorporate. أشياء مالية, أشياء مادية عفوا, وأشياء غير مادية. So, a structural approach means that we have to classify, right? This is art of taxonomy. But it also allows us to identify relations between these elements. For instance, a relation between two persons would be an obligation. الموجب هو علاقة مديونية ما بين الدائن والمدين. A relation between a person and a thing would be rather described in terms of ownership or real rights, حقوق عينية, سلطة شخص على شيء. And if the person is a public law person, such as the state or municipalities, then we will talk about public property law. This is an example of how a structuralist approach might go on. What are the main criticisms against structuralism? One criticism is its strong dependence on positive law. Why? Because we are comparing systems, and systems and notions and theories, they do have a starting point which is positive law. So we're actually relying on positive law to create our, or to pursue our comparative endeavor. Okay, so it is intimately linked to positive law. Whereas the functional approach, as we saw, would sometimes force us into finding solutions that are not contained in the positive law, but may stem from informal sets of rules. Another criticism is it's inherent to the creation and use of models. We will see models later on, or in the next video. We will explain what a model is. A model is a certain representation of reality, a certain simplification of reality, so we can understand it and build on it and compare it. But models are never real, and they will never coincide with reality, because by definition they are simplified versions, and they will never really coincide with reality. And a model will never exist in reality as it is. This is another criticism against structuralism, because models simplify reality and therefore may omit, they may ignore important nuances, which are very important and very necessary for a real comparative effort. But the distinction between functionalism and structuralism should not be exaggerated. For instance, certain comparatives, such as Constantinescu, said that we could have three alternative types of elements: structure, function, but also results. So a comparatist may sometimes resort to both approaches. Okay, they are not mutually exclusive. In practice, they often complement each other. Uh, they help each other and they complement each other. Finally, the cultural approach. Now, within this cultural approach, it is meant that in order for a true comparison, we should not stay at the surface. So we should not just compare between legal rules or systems or whatever. We should go beyond and compare the culture of each society. Now, of course, a legal thinker or a legal law person does not have does not have excuse me does not have all the competences needed for uh, for such studies. As I was saying, someone who studied law at School of Law do not have all the competences and all the skills needed for an extensive cultural comparison. Therefore, it is very important to rely on auxiliary fields, and fields that will help us, such as history, politics, sociology, to fully, or others, or anthropology and others, to fully understand the culture of a certain of the compared elements of the compared countries. Now, the good thing in this approach is that culture transcends systems, because in fact, one system could contain different cultures. Think about Lebanon, for example. Think about India, where you have different cultures in the same country. But sometimes you can find the same culture in different countries as well, where certain people would, let's say, exist in different states, and his culture there would be the same in these different states. So the approach based on culture may have this advantage that it frees us from frontiers of states. We are no longer distinguishing between legal systems as they are contained in certain frontiers, in certain territories, but we go beyond states. We go beyond nation states. We go beyond frontiers. How was culture defined? This is a very difficult task, in fact, how to define culture. So John Bell tried to define it as a tradition passed on by a generation to another, and of which judges and lawyers are the guardians. Frédéric Audran and Jean-Louis Alperin have a different or a similar, close definition, which is legal culture is a set of values, knowledge, and know-how guiding the activities of law professionals and giving sense to their activities. So we can say it is how one people, how one culture represents itself in its representation of law inside one community. And of course, legal studies and legal teaching, legal education is very important in transmitting a legal culture. For instance, the French legal culture got transmitted to us by mostly education. I will give an example: the outline of two parts, le plan bipartite, having two parts, two parts, two parts. This is an element of culture, a tradition passed on by a generation to another since the 40s of the past century. This would be an example of a cultural approach to comparative law. Now, within this current, the current of the cultural approach, we can speak specifically about the hermeneutic approach by Pierre Legrand. Hermeneutic is a word used to describe how usually religious texts are interpreted. So, in an hermeneutic sense, right, we are only interpreting a text, and this text is made of signs, words. right? Words are considered as signs. These signs hide a bigger truth. So we have to interpret the signs in order to discover the much deeper truth. So we have signifiers, which are the words, and signified, which is the hidden sense. If we apply that, if we extrapolate that to law, or to comparative law, excuse me, specifically to comparative law, so the signifier, the signs would be the rules and the norms, under which is hidden the signified, which is the mentality of a legal system. Mentality. So according to Pierre Legrand, a comparatist should interpret the signifiers, meaning the rules and the norms, which are considered as a surface thing, to understand and to discover the much deeper knowledge, which is the mentality of a legal system, the mentality of a legal system. So it takes into consideration the situated character of the interpreter and the situated character of the text. Now the result is that objective interpretation is impossible. So building on that, Pierre Legrand considered that it is impossible to unify laws because every law is just a signifier for something much bigger, which is the mentality of a certain legal community. And these mentalities are never the same. So why should we unify law? By unifying laws, it means we are also unifying the underlying cultures and mentality, which would be not a good thing. It would be kind of legal imperialism and enforcing a certain model, certain system on other people. And consequently, he was also against judgment of values on system, because he understood systems not as a set of rules and norms, but as the mentality lying behind them. So according to him, comparison should lead us to understand other systems, but not to explain them. If you think about it, there is a difference between understanding something and explaining it. Understanding means accepting it as it is. Explaining it meaning trying to find certain justifications for it or justification to change it later on. So these were the main approaches. I can mention at the end two other alternative approaches, which is essentialist. Essentialist comparatist, this is an old school. They focused on mostly the higher moral principles, so they are linked to studies of natural law, and equity, justice, etc. Postmodernist is inspired by social critical studies. So they are a bit close to what you already saw with Pierre Legrand, meaning that every legal text, every norm, every social phenomenon must be understood through the situation of those who made it. So therefore, there's no absolute knowledge, no absolute law, no absolute truth. Everything is relative according to whoever created this law or the system, etc. So unity of law is not something to be taken for granted. And a description of law can never be neutral, because whoever describing law will be biased by his own system, by what he already knows. I'm not going to speak more about this postmodernist approach. It is very interesting. It's very complicated. It has given, or it can be connected to other major schools such as feminist studies, gender studies, etc. But we will not dwell on it in this course. We will focus mostly on functionalism and structuralism.